Yes.
And maybe permitted to move an urgent petition as soon as bail application
This is regarding
regarding our anticipatory bail.
anticipation.
Anticipatory bail.
Okay.
Lordship, I would like to mention item number 29.
29.
This matter of after puja vacation or not? I on behalf of petitioner
What do you want?
listed after puja vacation.
You are for
I am for the petitioner.
appellant.
I have taken consent from the third party.
Okay. You are Mr.
M Lego
M.
Lego LEGO.
Lana counsel for the appellant with the consent of the other side. Praise for listing this matter after
Puja vacation.
entering puja vacation. The prayer is allowed. List this matter after puja vacation. Okay.
Obviously.
Might please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 18, Your Lordship. Your Lordship, as per record, Your Lordship, the service is incomplete here. I'm for the appellant.
Service is
Incomplete, Your Lordship. Yet to be received.
okay.
There is one
Mr.
in Kakum.
Hmm?
In Kakum,
Lana counsel for the appellant.
appellant, Your Lordship.
Okay. The service report is still awaited in view of the above. List this matter after 3
And
weeks.
Your Lordship, there is an entry. It may be continued, Your Lordship.
Interim.
Yes, Your Lordship.
The interim order passed earlier shall continue till the next stage. Okay.
Deeply obliged, Lordship.
May I please, Lordship? Lordship, I beg to mention item number 26 on behalf of D. Panging.
Item 26.
Lordship, the leading counsel could not appear due to personal difficulties. I have taken consent from the other party. Matter may be fixed after the puja bread.
You are for
Petitioner.
petitioner. Who could not appear yesterday?
Lordship,
You are Miss
R.C. Lawangcha.
Lana counsel for the petitioner submits that the conducting counsel has some personal difficulties today, hence pray for listing this matter after the puja vacation.
Yes, Lordship. And also, Lordship, item number
Prayer is allowed.
27.
List this matter after puja vacation.
And also item number 27 on behalf of D. Panging. Matter may be listed after puja.
May I mention on behalf of Mr. Dicky Pangalana, counsel, the appellant, with a prayer to list this matter after the puja vacation. The prayer is allowed. List this matter after the ensuing puja vacation. Okay.
Oblige.
My Lordship,
Yes.
Lordship, with the consent from other side, I beg to mention item number 28. Your Lordship, this matter may be listed after puja vacation.
You are for
I am for the appellant,
Mr.
Mr. J. Karba, on behalf of K. Lawyer.
appearing on behalf of Mr. K.
Lawyer.
Land counsel for the appellant, with the consent of the other side, prays for listing this matter after 3 weeks.
And that,
The prayer is allowed. List this matter after 3 weeks.
and Your Lordship, there is an interim order.
There is interim also.
Yes.
The interim order passed earlier shall continue to the next stage. Okay.
Obliged.
Your Honor, I'd like to mention item number 7.
Item
Item number 7 on behalf of Titawa petitioner. This matter may be taken up the This matter may be taken up the puja vacation.
you are for?
Petitioner
Petitioner.
Titaba on behalf of Titaba.
Okay, Mr.
H. Tai.
H.
Tai.
Tai. On behalf of Mr. Bitaba.
Titaba.
Land counsel for the petitioner. Prays for listing this matter after puja vacation. The prayer is allowed. List this matter after puja vacation. Okay.
Interim may be continued, Your Honor.
There is also interim. LCR is there.
Yes. LCS already received.
There is an interim, they say.
Yes, Your Honor.
Is it urgent?
Actually, I don't have the brief,
Okay.
so
The interim order passed earlier shall continue to the next stage. Okay.
Obliged.
And you are, Tado, are you
Yes.
appearing in this? case?
actually, matter is interested to H. Hage Lakshmi.
Okay, okay. It's fine.
Yes, Your Lordship, I beg item number 9. Lordship, I wish to withdraw the bail application.
Hmm?
Wish to withdraw the bail application, Your Lordship. Since the applicant is out of the state.
Okay,
you-
Mr.
P. Bate, Your
Planning
Lordship,
Council,
I'm at liberty to file the same.
P. Bate.
Here I'm
Planning
the
Council.
Yes.
engaged
Thank you,
lawyer
Your
of this.
Hmm?
Here I'm in the PP for the
Okay.
state.
P. Bate, Planning Council for the petitioner has an instruction to withdraw this bail application. The prayer is allowed. This bail application stands dismissed with liberty to file
Same.
the phrase. Okay.
Yes, sir.
This bail applications is dismissed on being withdrawn with liberty to file a phrase. As prayed for, liberty is prayed for. Staff. Mr. Taro is also present. Land additional BP. Okay.
Much obliged.
Obliged.
May I, Lordship? Lordship, I would like to mention item number 22, Lordship. Lordship, there is similar matter, Lordship. Same issue, Lordship. Born out of FIR. Same charge sheet, Lordship. Lordship. Lordship, this matter may be taken with the side criminal petition, Lordships, and list after puja break, Lordships, on admission column, Lordships. This LCR is there, Lordships. Same LCR, Lordship.
Okay. Mr.
Mr. G. Vam, Lordship. Petitioner, Lordship.
Land Council for the petition. Okay.
I'm for the state matter.
Yes.
This for SIC and I'm for state.
Okay.
This for SIC. This for SIC.
Yes, yes.
SSU.
And I'm for state.
Okay. So he's praying for adjournment.
Adjournment and take this matter, Lordship, with
Land Council,
123.
Mr.
G.
Land
Vam.
Council for the petitioner. Prays for listing this matter after the entering puja vacation along with the
One-
analogous matter,
123.
criminal petition 123, 2024. The prayer not objected by the Mr. Okada, Baron SC, and Mr. G. Taro, Baron Edison PP, State of AP. Accordingly, the prayer is allowed. List this matter after puja vacation along with the criminal petition number 123, 2024. Okay.
One.
Obliged.
Ah,
Much obliged.
After puja vacation.
Much obliged.
No.
Yes, sir. In this matter, the petitioner is the murder of one of the accused person who was apprehended in connection with one Itanagar woman PS case number 20 of 2024. The accused was arrested on 15/5/2024. She was sent to jail hazard in connection with the case, and the said case number was numbered as POCSO case number 8 of 2024, which is pending before the special judge.
Yes.
Now, Lordship may kindly come to the immune order dated. Immune order dated, the Lordship will find at page 12. Page 12. Order dated 16/7/2024.
Yes.
Yes. On that day, the daughter of the petitioner was behind the bar for 62 days.
Daughter
The-
of the,
The daughter of the petitioner. Petitioner is the mother of the accused person.
okay,
The accused named Lakshmi Gaur, Lordship will find at one report of the IO at page 14.
No, accused is,
Accused is Lordship will
Inside
find
the
the name of
custody.
the accused person at page 14 in middle portion. I'm reading the relevant portion in which the name of the accused person is being
page
named.
14 is what?
Page 14, Lordship will find the middle portion, whether the above four accused person would,
Which portion?
the middle portion, Lordship will find,
Yes.
name is there.
Which
Lakshmi
one?
Gaur.
Lakshmi Gaur, name is there. Age 26,
Hmm?
wife of Prakash Burman. At middle portion, Lakshmi Gaur and Puspa Mandal was also apprehended as pimp. They were declared as pimp by the arresting
Serial number
authority.
three, Serial number 3.
No, serial number 3, no. Lordship, can you come to middle portion? At serial number 1, Lakshmi Gaur.
Serial number 1.
Serial number 1, Lakshmi Gaur.
Yes.
And they are declared as pimp by the arresting authority.
So this serial number 1.
Serial number 1.
Is inside the custody.
Inside the custody. And we're making a challenge in respect of the order passed by the special
16-7.
judge at page 12.
16-7.
Page 12, 16-7, 2020.
What is wrong in it?
Yes.
What is wrong?
Yes. On that very day, the accused person behind the bar for 62 days. Charge sheet was there on 26th of this month, last month. The supplementary charge sheet have to be filed as per the order of the court. On that valid charge sheet was there. If charge sheet is there, mandatory period will come because so many persons were arrested. Nearly more than 50 persons were arrested in connection with this case.
Hmm?
More than 50 persons were arrested.
More than
50 persons were arrested in
50%?
connection with this case.
50% were arrested.
Were arrested.
What is 50%?
50 persons were
50% of the accused person
accused persons were arrested in connection with this PS case.
in connection with this.
And yes,
case.
when started,
How many accused are there in total?
in total, I don't have they make a
How do you know that it's 50% was arrested?
because as per the statement, as per the
Okay.
statement of the accused person.
Okay, what it has to do with this?
Yes, I lost time. Come to that. When charge sheet is laid down, charge sheet was at that relevant point of accepted by the special judge. My mandatory time can be 60 days. I already behind the bar for 62 days, 90 days, or it is a fit case for the accused person to behind the bar for a custodial trial. There must be some order in respect of the
Just a minute,
detention of the.
Just a minute. Let us read. What is this order?
Yes, this order, this very first time, this case is taken up for first time before this court being received of the charge sheet from SDPO Itanagar. On that day, I have behind the bar for 62 days.
The offense has been taken cognizance by this order.
But detention, I'm detained. I'm detained for more than, I may be, my mandatory period may be 60 days, 90 days, or
What
my
it has
case-
to do with? What it has to do with here in the while taking cognizance of the case? 90 days or 60 days, whatever it may be. What that has to do with? That day is to do with, because this is taking cognizance of the case after filing of the charge sheet.
No, charge sheet was there. Charge sheet was there.
After filing of charge sheet, the court has taken cognizance of the case. What is wrong with it?
But some specifications have to be there because the persons are detained because my case is not being proved.
What?
My case is not being proved because on mere suspension I was picked up. Because bail application was preferred and those were bail applications were rejected.
Okay. This is connected with bail.
Yes.
How?
No, it is not bail. Bail application is item number 8. Is the bail application.
No, the court has taken cognizance. My question is, what is there wrong in it?
Court may take cognizance.
Yes.
But what about the detention? Because we were appearing before the said trial court. Because we are appearing. We are appearing because court may take cognizance.
Yes.
If I'm not involved. If I'm not involved, if the mandatory period is there, for my
Case-
respective case.
The case has been taken into cognizance. If you are not involved, you participate in trial, or you make an
Yes,
your
and
argument
there's a provision of before
during
default bill
at the
also.
time of framing of charge, you make an argument for discharge. You'll get an opportunity to argue your case.
That opportunity is there, CC is there. I'm not on that.
So my question is, how you are aggrieved by this order, taking cognizance?
Court cannot detain. That is a
No,
technical
this
part.
is this a detention order?
The production warrant.
Protection warrant only, she was already there. Have you filed bail application? That is different.
He already prepared bail application that was rejected.
That is different, altogether different. The bail application, if you have filed, that will dispose of, she will be released if she is entitled.
Because if this charge have to be paid because charge was accepted by
So
the.
how the case will proceed? The case has been taken cognizance, how the case will proceed unless the UTPs are produced? So that is why court had issued production only, warrant only. For their production, and in the meantime, you can file bail application.
No. That is there. Bail application always been free because once rejected, she can
Yes.
again she can approach. I'm not on that. If in the charge sheet was there, material record is
Charging, have you received the copy?
no. Still
Get
that
the
we are
copy.
last appeared
Get the
before.
copy. Next time on his appearance, next date is fixed on when?
Next is 14/11.
16/9
No, 14/11.
Already expired, Your Lordship.
expired, and
Yes.
thereafter copy must have furnished to the accused.
No, on 26, 9-day last production date was there. We appeared before the Learned Trial Court,
The accused
but
must
no
have received
no
the
copy.
Accused must have furnished the copy under 207 CRPC.
No copy was served.
Then you just apprise the court that we need a copy. If the copy was not furnished.
Copy was not furnished on the last.
Your Lordship, in motion, item number 3, again, that is your matter, right?
No.
The other, Your Lordship, this matter has already come before Your Lordship in many occasions where all the charge sheet has been annexed, Your Lordship, the bail application, this.
In the bail application.
Yes, Your Lordship, Your Lordship may aware of this women trafficking and POCSO matter, this
Yes.
is related to same case. And so far as this order is concerned, it's just a PT warrant, Your Lordship, which is passed under 267 of the CRPC. And it's an interlocutory order, first of all, and they have assailed the same under revision petition. It's,
No, revision can be filed, but then what I'm asking is how he is aggrieved by this order, if
Yes, Your
since he has come into revision.
yes, Your Lord. Revision, Your Lordship, that order should be final one. It should be affect the right of a person. Now, so
Taking cognizance can also be coming to revision, but
Yeah,
then
but-
how he is aggrieved?
here, Your Lordship, he is challenging the PT warrant, Your Lordship. The court cannot issue this PT warrant. The court can issue, Your Lordship. The special court has clothed with the power of
Court can issue.
Yes, Your Lordship. There is no any infirmity in the order of 16C7/2024.
Yeah, I'm asking.
And that part is already gone, Your Lordship. The next date was fixed on 16/9/24. That is also gone. They have to challenge this order also, if they are agree.
Then another
Now,
date
now
was
if
gone.
you have to challenge this order, then the another order,
Yes.
16/9, and then thereafter also some order must have on 16/9 also.
The second and
some order
after that
must
there
have
is another production date on 26/9. 26/9. That was also we have appeared before there, but we are not preparing any bail application there.
It's not maintainable at all.
That need to be incorporated if you are really aggrieved by this order. Better you withdraw this and then come with if you are really aggrieved, and if you are your submission is perhaps about his detention or hard detention, and then bail 60, 90 days, etc. Okay, so that if you are aggrieved, come with a clear picture.
Because in subsequent orders, we're finding that no such specific order was passed because if I'm behind the bar, if no reason assigned, I'll be behind the bar for forever.
How?
If my case, if I'm involved, court may write that yes, your case is a fit case for custodial trial. Something have to be viewed by the court that I cannot detain in sake of a case for good.
You have a liberty to file bail application for that purpose.
Bail application there in the item number 8, bail application is there in that case
Then-
that may be called.
When in the
In
your bail
today's
application, let
list,
bail application be disposed of.
my bail application is pending.
It's
in-
pending here.
Here.
Okay.
Today itself, item number 8.
Item 8.
Yeah, no case there was called for. It was only specified the
Okay,
notification
so
number.
what to do with this case? Because thereafter also 16/9/2024, some order must have passed.
Mm.
And when it is, the next date is fixed on?
Next date is
16/9.
14/11.
14/10.
14/11. 14/11.
14/11.
14/11.
Okay, then this order should also come. 16/9/2024.
69 and also
The same.
Victim needs to be completed there.
Where?
This.
item?
It will come.
No, we are in one.
it is same cause of
No.
action. Connected.
So what to do with this? What do you want? You withdraw? Come with,
I come with that along with
Because-
those orders. Those orders I need. Because I appeared on the last occasion on 26/9/2024, not in 16/9. But no copy was served.
when this was filed, by the way?
Your Lordship, on 30. Yesterday, I think.
39.
30, this, yes, Your Lordship.
Yes, then you could have annexed 16/9/2024, so you did not do that also.
Yes, Your Lordship. And perhaps, Your Lordship, they have to challenge the remand order in that case. This is not the remand order. This is the production order.
This is taking cognizance and then the production order. Production order, how can you challenge? How the case will proceed without producing the UTPs?
I mean, that's a different issue, but
You have to-
in
you have to
respect of
clarify.
detention.
You are agreed by which order?
Page number 12, Your Lordship, 16/7, that is the
Where is the
production.
detention? Where is the detention?
They have not annexed. any-
Detention order is something else again. By different order, it will be, but then
Okay, Lordship will obtain all those orders and will come with an appropriate application.
Hmm.
निकल लेगा सब निकल लेगा
because till then, the
Because
accused was not present on that day. Is it?
ऐसे नहीं
Your Lordship, the date was fixed for 16/9.
Yes. That should have been the impugned order. If you are agreed, but. What to do? What do you want?
Okay, Lordship, I will do and come back
Mr.
with the appropriate application.
Okay, Mr. You are Mr.
RP Hazarika, RP.
Okay.
RP Hazarika.
Hajarika, direct counsel for the petitioner wants to withdraw this criminal revision petition. You want to come back with liberty
With
to
liberty.
file afresh if so advised. The prayer is allowed. This criminal revision petition is dismissed with liberty as prayed for. With liberty as prayed for. Stop. This present may also be required. Mr. Ete, T Ete. Then additional PP is present. Okay.
Yeah, if
Lordship,
you-
and item number 8, Lordship, look,
Let the
you
matter-
call for case diary.
Yes, there is there.
No, Your Lordship, it is listed for the
No,
first
but
time. Listed for the first time.
Item 8.
Yes.
I ate it.
8 also listed. First time. Wait, hold your turn. Yeah.
Here, your Lordship,
Victim is
Okay, you are go.
POXO matters, POXO case is also there.
Other matters are also the connected matter.
Yes, this is connected with the item one. Here, victim needs to be implicated or either legal guardian
Just a minute, yeah.
need to be implicated.
This is bail application.
This is bail. This is what's the bail.
You have it state only. So. Yes. Notice is to, a victim has to be informed or the informant. You have to implicate the victim also, victim. Or the informant. Who is the informant is somebody else.
Yes,
Okay.
informant is CWC,
CWC.
Child
Okay,
Welfare.
informant. You have to implicate the victim also. For Or
Let-
when do you want?
Let it be very clear, it should not be by name.
Lords may fix.
It should not be by name.
Lords may fix any day. Any date, Lords may fix. Any day. Any date will implement by filing an
File
application.
fresh or
Oh,
Hmm?
fresh is better. Well, fresh and fresh
fresh,
application.
okay.
Same, Mr. Raj Kumar, who wants to withdraw this bail application with liberty to file afresh after making necessary correction. This bail application is dismissed on being withdrawn with liberty as prayed for. Okay.
Highly obliged.
Available.
May I Lordship?
Yes.
Lordship, this revision is filed against the notice and notice of Corona Lordship issued by the Interplace Customary Court Lordship, Pasar Leparada District Lordship, and subsequently passing the impugned Kaba decision Lordships. Lordship, the complaint was made before the President Annexure 1 Lordship. This complaint Lordship, Annexure 1 Lordship, may I read Lordship?
Where is complaint?
Complaint Annexures 1 Lordship, page 16 Lordship.
Yes.
May I read Lordship?
Yes.
To the President's Gaubura Associations Laparada District. Complaint against Sri Iken Ram and Sri Karsen Ram of ECC2 Place. Respected sir, with due regard and humble submissions, I do hereby lay down a few words in your kind consideration and necessary action, please. That sir, I Sri Motu Ram, owner of LA Enterprises Place Chirna, that sir, name mentions 2 persons used my farm for constructions of Panchayat Bhavan Common Service Center at EC Tiku Gram Panchayat, the sanctions of rupees 25 lakhs. In this regard, after first and final bill, they are not paid my GST fee, which liable to my enterprise with an amount of rupees 4,83,500, which I have to pay the government tax. So, your honor is requested to settle the case and solve as early as possible.
So,
On to that effect, Lordship, notice was issued, Lordship,
by
by Annexure 2, Lordship. Lordship, top Annexure 2, space 17, Lordship. Office of the Interplace Customary Court, Pasar, Lordship. Lordship, translation copy. Annexures 18, Lordship. Lordship, may I read relevant portion, Lordship?
yes.
This issued by the Office of the Interplace Customary Court, Pasar, by fixing the cover on 27 2024, Lordship. After
Page
that,
18.
yes, Lordship. Lordship, and just below the paragraph 2, Lordship, that is that is
Yes.
there, Lordship, 27 2024. The cover was fixed, Lordship. But Lordship, due to some personal difficulties and personal problem, Lordships, the herein the petitioner's Lordship request an application, made an application, Lordship, with a prayer for postponement of the date of the case,
You
Lordship.
did not appear.
Yes, Lordship, we not appear on that day, and request was made, Lordship.
Okay.
And Annexure 3, Lordship, postponed, Lordship. This is postponement application, Lordship. Type copy is at Lordship, page 20, Lordship. May I read, Lordship?
It's okay.
Just subject, Lordship.
Okay.
A
Request for postponement.
Yes, Lordship. On that,
Okay. Then what happened?
and that basis, again, Lordship, reporna, Lordship, re-notice, Lordship, issued by the President, Lordship. Annexure 4, Lordship, page 21, Lordship. Lordship, and type copy, translation copy is at page number 22, Lordship. Report now, Lordship. Again, fixed, Lordship, by inviting GABA members from the other villages, Lordship. And fixed on 7 08/2024 lordship. And to that effect, lordship, being aggrieved of this reporter lordship, the petitioners lordship, one lordship, again submitted a representation lordship, Annexure 5 lordship,
Yeah.
23 lordship.
Hmm.
Type copy is that lordship 24 lordship. Recalling of Purna notice dated 29/07/2024. May I read lordship? This is important lordship. It is informed your kind notice is a notice of Inter-Blaze Customary Court, who is an appellate court of order passed by Blaze authorities. Lordship, here lordship, the Blaze, the Inter-Blaze Customary Court is the appellate forum lordship of Blaze authority lordship. I will explain from the lordship, FR lordship.
So the
Currently
application is addressed to the president,
Yes, lordship, president is issued.
but then the Purvana or
Purna
Parvana was
is issued by also president lordship.
but, okay, president.
Yes, lordship.
What-
Henken Basarkom GV president lordship. Gao Bura welfare
By this,
president La Parada, same man lordship.
by
He
this,
is
what the applicant want to say?
want to say lordship, past lordship, here lordship, the Blaze authorities, lordship, from where lordship, the petitioners, as well as the respondent lordship, sole respondents, belong from EC Chiku Blaze lordship. For the reasons that lordship, Blaze authority of EC Chiku Blaze have a jurisdiction to try the case lordship.
And who, this president is where?
President
From
is
where?
from, president is from Soy Blaze lordships.
Different village.
Yes, lordship, different Blaze lordship. Lordship, this orders, impugn notice and order is in violations of lordship, section 24 of FR lordships. May I read the section 24 lordship?
What is that? What it says?
It says lordship, Inter-Blaze Customary Court is the appellate authority of the Blaze authority lordship.
Okay.
Lordship, if lordship is perused lordship. May I read lordship?
Yes.
Section 24 lordship.
Hmm.
Any aggrieved by the decisions of Blaze authorities may appeal within 30 days before Inter-Blaze Territory Customary Court or Apex Court by whatsoever name called, who on receipt of such appeal shall dispose of the case. Lordship, here is the case, lordship. He is the appellate
Will
authority.
issue notice?
Yes, lordship. And lordship may please to stay the impugn cover decision.
Whether the record can be called or what record is not possible.
Record is lordship, customary court lordship, its records, it's
Not
not
possible.
possible lordship. We enclose the certified copy issued by the president itself lordships. Cover order lordship.
Okay, hard, Mr.
Annexure 6 is the impugn order lordship, cover decision lordship.
Hard, Mr.
G BAM lordship.
G. Bong. Land Council for the petitioner. Start. Fire. Constitution of India. The petitioner, as I said, the impugn Purvana, P-O-R-W-A-N-A, within bracket, Keba Samon, A-E-B-A, Samon, bracket close, dated 13/7/2024. And Purvana, P-O-R-W-A-N-A, dated 29/7/2024, issued by the HGB, huh? Soy Village.
Yes, he is Soy, he is the AGB of the Soy Blaze.
No,
The president
so-
of La Parada lordship.
On what capacity he has issued?
He issue in capacity of the lordship.
He has not
President-
written a Soy Village.
Yes,
Okay,
yes,
issued by
but president lordship.
head GB GBWS, head GB huh? HGB means H stroke GB, come GBWS capital, huh? President LRD,
La Parada district, Lordship. This is
Leparada district, okay, President Leparada district.
Lordship, as well as challenge the impugned Gaba decision, Lordship, on the basis of this, Lordship, impugned Porna, Lordship, in exercise, Lordship.
Whereby the petitioner has been summoned to appear before the said head GB, come GBWS president. LRD, huh? Leparada district. Stop. The petitioner has also assailed the inter-village Keba decision dated
Yes, Lordship, 07/8/2024.
7/8/2024, passed by the inter-village authorities led by,
President, Lordship. Presidents,
where is the decision?
annexure, Lordship, 6, Lordship, page 25, start from 25, Lordship. Annexure 6, Lordship, type copy, Lordship, start from translation copy, Lordship, start from 29, Lordship.
Okay, headed by, huh? Decision headed by head GB, come president GBWS Basar Leparada. So it is submitted that the head GB, huh, come president GBWS Basar Leparada district has no authority.
Yes, Lordship, straightway he cannot, Lordship. He is the appellate authority, Lordship. Agree of the place authority
issue
on the past, Lordship.
the impugned Parwana dated 13/7/2024, comma 20 and 29/7/2024, and he has also no authority to pass the impugned Keba order,
Kaba order, Lordship, inter-place Kaba order,
inter-village Keba order
07.
dated 7/8/2024. And by passing the above impugned Parwana and the Keba order, comma, the at GB come GBWS President LRD Leparada, huh, has exceeded the jurisdiction. Exceeded his jurisdiction, huh? Stop. Issue notice. Returnable by 4 weeks. The petitioner shall take steps upon the respondent. How many respondents?
Only one, Lordship. Sole respondent, Lordship. Complainant only, Lordship.
By a register post with 18, as well as by the usual process. Start. Within 7 days from today. By a register post, huh? Within 7 days from today, huh? Stop. Back. List this matter after 4 weeks. Para. In the meantime, what is the direction there?
Lordship.
What is the direction in the impugned order?
Impugned order for direction to pay the GST amount, Lordship, of 16%, where he claimed for, complainant claim for the 18% lordship. Impugn order lordship, 16% was directed to fail lordship.
GST to be paid to whom?
GST to pay to the complainant lordship,
Complainant.
lordship. As per directions of the Gaba decision lordships. Lordship, if peruse lordship.
In the meantime, till the returnable date, the operation of the impugn Gaba decision dated 7/8/2024 shall remain state. Okay.
Much of it.
Yes.
See, this, this matter is regarding bail application under section 483 of the BNSS, for granting of regular bail to the accused, namely Dipali Basumatri, Dulal Basumatri, Deepak Paranjuli, and Nanda Ram Bora. Lordship, they were arrested on 20/05/2024 in connection with POCSO case number 8/24 in the court.
When they were arrested?
20.
On the
20
same day?
No, Lordship. Deepak Basumatri, Dipali Basumatri, Dulal Basumatri, and Deepak Paranjuli, they were arrested on 12 May.
Why you have filed in one bail application? If they were arrested on different dates, and if they have committed the same offense,
No, Lordship.
then why in one bail application? Their bail condition also will be different if they have not committed the same offense, similar offense.
Yes,
That
similar offense, Lordship. Similar offense. Same
role.
Then if they have the same role, then when one bail application is rejected, then all will go, your lordship. And secondly, your lordship, whether there is an authorization.
And then if no the similar offense, then the bail condition also will be different. The amount of the bail amount also will be different.
Yes, yes,
In a case, I remember still,
yes, yes, your lordship.
one was just, he was innocent, it appears, but the other one was the main accused. Then the bail condition had to be given same,
Yes,
similar
yes.
2 lakhs.
Yes, your lordship.
In order to avoid
Lordship,
fear
there,
stamp, why you have filed?
the Lordship, the accused persons are not named in the FIR, and the entire case,
Who is not named in the FIR?
all the 4, Lordship, all the 4 accused. They are not in the FIR. and
So the
entire-
ladies are also there,
Yes, Dipali.
gents are also there.
This is related with the same item number 1 matter, your lordship. Same fact.
Okay.
Revision, when revision was filed, your lordship. And an earlier occasion, your lordship has rejected one of the accused bail
Some
application.
would be supplier, some would be facilitator.
But Lordship, the bail application, moved before landed trial court was rejected by common order.
Rejection can be by common order.
Only, your
What is
lordship.
the status? Ritu?
Lordship, I pray and request for CD may be called.
Not case diary, TCR, your lordship. The trial already commenced, your lordship.
Okay.
Trial already commenced, and
What
here
did you file bail application before the trial court? You have filed.
Yes, Lordship. It was rejected.
Where is the rejection order?
It's in,
Yes,
Annex 5.
Hmm?
Annex 5.
Page
Your Lordship, in page 120, Your Lordship. On 8/8/24.
Hmm?
8/8/24.
120.
Almost 1 month back, Your Lordship. 120, Your Lordship.
This was rejected on 8/8. This rejection was after filing charge sheet,
Yes, Lordship.
after the trial commenced. After the trial had commenced.
Yes, Lordship.
Okay, then what is the new ground you have taken?
Lordship, it's already, they have completed 130 days in
So what?
custody.
So what?
And
The charge sheet already filed. It is on the trial. The trial court would be the best court to consider whether the accused can be released or not.
Lordship, the entire case against the accused person rests solely on the statement of co-accused, Punima Mili, which is admissible and evident, Lordship.
That is why you make a plea before the trial court. Because it is with the trial court, the record is available with the trial court.
It's already rejected, Lordship.
So that is why I'm saying, after considering all that the learned trial court has rejected, what is the new ground we have taken for filing bail application before this court?
Lordship,
On the same ground, how do we reappreciate? How do we pass order that this is bail application only, not revision? On the same ground, how do we release you?
Lordship, they are filing for the first time in the High Court.
Yes, you have filed there for the first time. And here also first time. So that is why I'm asking, you are filing here for the first time. What is the new ground you have taken? The ground which you have taken before the trial court. Trial court has appreciated everything.
Lordship, they are in custody and they're making sufficient defense. Lordship, they are because they are facing a problem for trial. As the accused are in custody, Lordship, they will be prevented from taking sufficient defense in the trial, Lordship, which would cause great injustice.
Trial court must have considered all those. You must have pleaded before the trial court also the same thing, isn't it? So yes, what to do?
Your Lordship, they have filed the joint one, and Your Lordship, the second concern is they have filed, the sole person has this sworn an affidavit on behalf of.
Oh,
So whether
how
there
that
is
can be done?
there is an authorization or not by this accused or not, that has to be looked into, Your Lordship. Page
Affidavit is to be filed.
Page number 9 is the affidavit. Page number 9 is the affidavit, Your Lordship.
Page?
9.
So it has to be affidavit. Is to be
Affidavit,
filed
yes,
by
has to
both.
be, authority has to be given by the concerned accused person, Your Lordship, countersigned by the jail authority. Otherwise, we will not in the position to know whether they are in the custody or not, if it is not countersigned by the jail authority, Your Lordship. So if they have
Who has
annexed
signed this affidavit? Yes.
affidavit
who has
in
to sign?
page number 9.
Endorsed by the jail authority. Isn't it?
Yes, Your Lordship, it has to be endorsed by the jail authority.
No. So don't try shortcut. Fulfill the procedure, file properly. Even if you want to file in one application also, it has to be signed. The affidavit is to sign by all and then endorsed by the, who is this one, the applicant, the petitioner?
Anand Ram Boro, he's the son of Surendra Boro, and
It has to be endorsed by jail authority.
he simply stated that he's a relative of the
No,
accused person.
No. You can't. Probably the registry is to check.
Yes, your lordship.
Registry also has not checked. That there is a 4 applicant, the 4 accused persons involved
Yes.
in paying for the grant of bail. It has to be endorsed by the jail authority that they are in the under the custody.
Yes, your lordship.
There is a defect. You file again. Okay.
Withdraw करके trace file में.
You are Miss
RC Lobamcha.
R.C. Luangcha, Learned Counsel for the petitioner, wants to withdraw this bail application with liberty to file afresh after making necessary corrections. So the prayer is allowed. This bail application stands and is dismissed with liberty as prayed for. Okay.
Yes, deeply obliged.
Please.
Yes, Mr. Madhu.
My lord, the instant criminal petition has been prepared against the FIR lodged by the Deputy Commissioner Colorian on 17 April 2020.
Against the
Against the accused person.
Okay.
And there are many accused person, but only one accused before the lordship here.
okay.
So I will take it to the lordship to the FIR in page number 21.
This is for quashing.
Quashing, yes, praying for quashing of the FIR in respect of the petitioners.
Okay.
Because there are many accused but the petitioner before the lordship is single.
Okay.
In the
FIR is at
FIR is at page number 20 and the 21 is type out copy. Will be more visible.
21 is type out. Okay.
In lieu of the upcoming simultaneous election 2023, the following officials are reported for the willful neglect and the refusals of the discharge of the election duty and responsibility assigned to them, since they refused to attend the polling duties on the day to disperse responsibilities assigned to them, since they refused to attend the polling duties on the day of the dispatch without prior information and approval. Therefore, the regular case under section 134 of the Republic of the People Act 1951 and the section 166 of the IPC and the other appropriate provision of the law be registered against the following person. Now, my lord, I am my name in page number serial number 17.
17.
Yes,
Where
within
is
the,
17?
within this accused within the accused list in serial number 17. So accordingly, this has been registered as Colorian PS case number 4 under section 166A IPC and read with the section 134 of RPA XML. Now I prepare to take the lordship to the backdrop of the FIR before coming to what had happened after the FIR.
Let us, you have completed, who are the respondent parties here?
Deputy Commissioner is a complainant.
Deputy
Commissioner is a complainant.
Deputy Commissioner, in the capacity of the Deputy Commissioner, so
Okay.
is respondent number 2.
Okay, yes.
Now we'll take the lordship to the backdrop of the FIR. Kindly come to the page number 54. 54. This is the first, my lord got it, 54.
Yes, 5-4, type copy.
Type out copy. In view of the upcoming general election 2024, the DO office Coloriang is going to conduct the pass training of the presiding and the polling officer of 21 Coloriang STAC and the 19 Nyapin STAC at the district headquarters Coloriang and then respectively as scheduled below. So this schedule below, and accordingly, my name is there in Lordship. May kindly come to page number 56. My name is appear in the serial number 110. Page number 56.
Yes.
In serial number 110. And my post is legal counselor. Legal counselor. I'm one of the practicing. Lordship may kindly come to the page number 60. This is the second notification passed by the my lord informant, wherein in view of the coming election of the district election, Coloriang is going to be conducted, held on the training and the theoretical session on EBM BB PH4 presiding officer and the office of the 21 Coloriang ST Assembly Constitution at the district headquarters Coloriang as per the schedule below. And accordingly, my name kindly come to the page number 62. Lordship will find my name in the serial number 34 as a legal counselor, my lord. Thereafter, my lord may kindly come to page number 65. 65.
Yes.
This is the order that the medical board is hereby constituted comprising the following members and examine the application submitted by the various officers and the request for the exemption of the election duty on the medical grounds. So this particular order was fixed that the person who would not able to attend the election duty on the medical ground should appear, man. Accordingly, thereafter, this was fixed on 2nd April 2024, and the date for submission of the physical document is on 5 April, meaning thereby, my lord, the officer who has been assigned to the duty who could not able to appear on the medical ground should appear before on 5 April 2024 at the conference hall as per this order. Thereafter, my lord may kindly come to page number 66. Now, the last date for appearance is the 5 April. Thereafter, what happened, my lord? Till that, I have no problem. I am accepted that I was ready to assign the duty as assigned by the officer. But unfortunately, I fall illness on 8 April 2024. Therefore, my lord,
on
8 April 2024.
What happened there on that day?
Therefore, my lord, this medical prayer for the leave on the medical ground was there.
This is
thereafter, I was admitted at the, my lord, in the Niva hospital, and it's appeared.
Last date was 5th.
My lord.
Yes.
Okay.
Till the last date, 5th, I was all right. Despite that, I am having some ailment in my body, but at that moment, my disease was not active. But suddenly on 8th, I fall illness. And my lord will find in page number 68. Here,
What is 66 is?
66 is the application praying for leave on medical ground. Because on 8th, I fall illness. Therefore, thereafter, I have been admitted to the Niva hospital. So on 9, this application was submitted before the district election officer, praying for exempted me from the duty on the grounds of the medical. And my lord will find in the page numbers, it is start from 68. These are the medical record. And Thereafter, it's important to show the
See,
lordship.
the government has constituted board.
My lord, on page number 81,
Wait, the government has constituted board and then directed you to appear. You appeared there, had your checkup,
I have released,
found,
I was
and
released from my lord, the medical
now
on
this is NIBA is a private hospital,
my lord.
knowing that the government has checked your health and you were found fit.
No, my lord. I was not checked. Oh, so far, my lord, the 2nd April notification says of the 2nd April is concerned that whoever poll before the my lord that 2nd April 2024. So I was not before the medical board because at that time, my lord, I was okay, man. My health was okay. Therefore, my lord, in page number 82, 81, my lord will find that there I have released from the
Thereafter, there
hospital.
was no medical board constituted by the.
My lord, medical board was constituted on 5th April. Whereas, my lord, after the conclusion of the medical board, my lord,
This is you fell ill after attending the duty.
no, my lord.
So duty was to be, election duty was to be attended when?
Election duty was supposed to be, my lord, attended on 19 April, my lord, in the last election. So, medical, I was released on 8/4/2024. And my lord, I tendered my resignation on 10/5/2024.
Resignation.
Yes, my lord, resignation from the post as a councillor. My lord, I am serving as a councillor in the top center at Colorium, my lord. Stop point center at Colorium.
Page 83.
Page 82, man. Thereafter, what had happened after the FIR, I will take the lordship back to the record that after the FIR, I was recorded under 161. My 161 statement is my lord appear in the page number 24. After the FIR has been registered, my lord, this is type out original in page 23. My lord, got it 24. Page 24. My name and address as above mentioned are true and correct. I am working as a legal counselor, contractual at the One Stop Point Center, Colorium since the last 2 years. I have attended the election training on 4 March 2028 and 5 March 2024 respectively. On 8 April 2024, I had a serious illness problem and accordingly undergone treatment at the Niva Hospital, Papunula, Naurlagan, and the same was informed to the authority, DEO Kurunkume, by filing a leave application on 9/4/2024 on the medical ground. On 16/4/2024 and 17/4/2021, I was taking a medicine and antibiotic injection at the Niva Hospital due to my serious health problem, and hence I was unable to attend my assigned election duty on 17/4/24. But there was no willful neglect to discharge the election due to, in fact, it was only due to my health problem. Further, I am to state that I was under the medical treatment at the Niva Hospital, Naurlagan from 8/4/24 to 24/4/2021.
Okay.
That is my statement. Now in the charge sheet, my lord, may kindly come to the page number 35. In the charge sheet, I have gone through the charge sheet, out of 25 accused, only 12 accused has been, my lord, charge sheeted. And lordship will find in page number 35, I am in the serial number 11. My name is in the serial number 11.
Serial number 11.
Yes, page 35.
Yes.
Yes. And according to what the FIR says in, my lord, may come to the page number 46.
Yes.
This is the charge sheet story in wherein my name is appearing in the serial number 1717. Legal counselor, and I will take the lordship to the page number 49. Is the conclusion of the FIR.
Yes.
From the above facts, I'm reading the last portion.
Yes.
From the above facts and circumstances of the case, including the statement of the informant, witness, and the alleged accused person, and all the documents seized collected during the investigation of this instant case, it was found that most of the alleged accused person were absent on the day of the dispatch, that is the 17/4/24, without prior information and approval from the authority. Thus, they willfully neglect and refuse to discharge the election duty and responsibilities assigned to them by the DEO Kurungkume. As such, the prima facie case is well established against the following 15 alleged accused person out of 23. Under section 166A, IPC read with the section 134 of the RPA Act 1951. So my name is appeared in the serial number 11. In view of this, Lordship will be to me, and accordingly I appear before the magistrate on the last occasion on 4/7/24. Despite that, I have intimated the reason that I should be dropped from this spot, but they dropped from this present case, but that was not accepted verbally on saying that they after conclusion of the
Why you should be dropped?
trial. Because why I should be dropped on the ground that there was no any willful negligence on my part, but it was because of my healthness, but because of the health issue.
Says that you remain absent without information given.
My lord, that is the wrong statement. Since I have already informed, when I fall sick, when I get admitted in the hospital,
Is there any receipt of your information
my lord,
to the department?
exactly, my lord, on 19, my lord. That so far I remember, my lord, I have read out that I have informed to the authority that I am supposed to take up the duties, but because of my health issues that I could not, my lord, participate.
Whether your application reached the authority?
Yes, application was
Where-
duly,
where-
application was duly received. That
Where?
application in page number 66, my lord, that we have already gone through. And this has been received by the
Where the receipt?
page 66, my lord, may kindly look it again. So this application was received on 10/4/2024, PA of the Deputy Commissioner, Kolori and Kurungkume. So my lord, on anticipation that my case is deserved to be considered since it was on the health ground, my lord. On that anticipation, my lord, I was waiting there. But in the meantime, I have been charge sheeted, my lord. So far the charge sheeted, my lord, is concerned, this 166A is the breach of the official duty in connection with the election. So the punishment is 6 months, likely to be extended for 2 years.
Not
But
compatible.
despite that,
Non-compatible.
non-compatible.
Okay.
That
And
is
the
why I am
RPX
here before. And at the same time, this 134 RPX is also same. That this evidence of the public servant by the public servant to
Yes, Mr.
by the
Chairman.
office note. Therefore, my lord, my submission, my lord, as a argument point of view, here, my lord, I have been compelled that despite of the illness, once I have accepted the, my lord, the
Okay.
assignment.
Yes, Mr. Taro.
So, my lord, there is a prima facie case with, my submission would be,
You can issue notice.
my lord, without notice also, there is. a
How
prima
without
facie
notice? What
case.
are you saying? Please.
A notice may be issued.
Hmm.
And TCR may be called for because it is already charge sheeted matter.
Hmm.
This is a though punishment is extended up to 2 years, but this is a serious offense of the not disobeying the command of the superior authority.
Election duty is covered.
TCR may be called for scan copy of.
Third, Mr. C. Modi, Learning Council for the petitioner, staff. Para, this is an application under section 528 of Bharatiya Nagarik Suraksha Sanhita, within bracket BNSS, from 2023. Praying for quashing of the FIR dated 17/4/2024, registered as Koloriang PS case number 04/2024 under section 166A of IPC, read with section 134 of the Representation of People Act 1951, corresponding to GR case number 09/2024, and the subsequent proceeding of the case. Is case before which court?
Before the JMFC Koloriang, my lord. In respect of my lord, in respect of petitioner, my lord. Because there are many accused.
Okay.
Therefore, I cannot establish the entire other accused. In respect of petitioner.
the petitioner. Staff, huh? Issue notice. Record needs to be called for, sir.
Yes, TCR, trial court record
Call for the scan copy
of TCR,
of
trial court record, TCR.
trial code. Scan copy, huh? Trial code. Issue notice. Returnable by 4 weeks. Start. It will be Koloriang, if it is Koloriang, then 5 weeks.
Yes, after vacation,
Okay.
because today is
5 weeks. Start.
from 5, vacation begins.
Mr. Taro, additional PP accepted notice on behalf of the respondent number 1.
And she is to
2.
Yes,
You are
number
for 2. Okay, and Miss appears on behalf of the respondent number 2. Since the parties has appeared and accepted notice, no formal notice required to be issued. Staff. However,
Matter be fixed for admission hearing.
the petitioner shall furnish requisite extra copy to the Learning Council for the parties. Respondents, staff. List this matter after 5 weeks for admission. Okay.
Till then, my lord, I may be exempted from the partition.
I
Further
have,
proceeding.
I have objection in that
Petitioner.
regards,
Only in case of petitioner, my lord.
Now let us see the record, the
Yes.
interim prayer.
because, there are not only one accused, several accused are there.
On the next stage, on receipt of the records. Okay.
Highly obliged.
May I, Lordship?
Yes.
Lordship, here the petitioner is invoking the inherent power of the High Court for challenging the impugn order 35 of 2023, whereby the learned JMFC Court has condoned the delay of 77 days without even issuing notice to the accused person in a check bounce case. Lordship, in nutshell, Lordship, the brief of the case is that, Lordship, here the petitioner before this honorable court is a land broker. He had a mutual agreement. He was issued a power of attorney by a landowner saying to sell a plot of land that it's around 1,75,000, some big, huge land. You know. And Lordship, here the respondent, who's the complainant, had approached with saying that I'll sell, let me also be a part of this. If the land is sold, I'll bring a prospective buyers. If the land is sold, you ought to give me a 60 lakhs as a commission for selling the land. According a mutual deed of agreement was executed between the petitioner and respondent, is the complainant, and saying that if the land is sold and half of the amount is given to the landowner, then the 60 lakh as a commission will be given to you. And accordingly, in meanwhile, since the petitioner could not sell the land, a power of attorney was terminated by the landowner. Meaning thereby, Lordship, the mutual agreement between the petitioner and the respondent that has become infructuous. And lordship, in the entire petition, also in the complaint petition, they have not made any averment where I have given him a check. The check was given for some purpose as a security in other land settlement agreement. Since lordship, I'm a land broker. Be it that may lordship, but there was a delay of 77 days when they had filed this complaint case under section 138 of NIA. Lordship, when there is a delay, the trial court ought to have given a opportunity to the accused that the reason, even without issuing notice, lordship, the delay was condoned and the cognizance was taken against, and I was to issue summon by the trial court below.
This is by way of,
By way of lordship, I have made the 482/528 of BNSS.
this is quashing.
Quashing lordship.
So why? You have an impugn order, delay was condoned.
Yes, lordship, that's what I'm before this on inherent power of this honorable court. The learned trial ought to have at least issued me a notice while dealing the condonation delay petition.
What lies? The revision or?
Lordship,
lies
482
against that
lies.
order?
It will be 482.
Against that impugn order?
Yes, lordship,
Will
I
it
have
go-
challenged the entire proceeding, lordship, since there was in the entire petition also, lordship, there is no any legal debt liability between me and the respondent. So before, that's why lordship, I'm before this honorable court. May I come, lordship, if I'll come in a sequence wise, this, I can satisfy this honorable court. Whether there was any debt liability between the petitioner and respondent. For
What is the status of the,
lordship, that someone has, I had appeared before the honorable court. And like the next date is fixed for offense explanation has been done is for CW, complainant witness, lordship.
so, okay, the respondent did not file any FIR.
No, no
Only
FIR, lordship.
File under NIA.
Yes, lordship.
The respondent has filed only under NIA.
Yes, only NIA
Okay, for check bounce.
for a check bounce case.
So check was issued for some other,
Yes, lordship, in
what was the amount? Is the agreed amount was 60.
60 lakhs,
What
as
is
a
what is
commission.
the amount here?
Lordship, the check instrument amount is also 60 lakhs. And lordship, in the averment also they have made, the check was given to some other Gaompura in a land settlement where I had given to other party.
You can issue notice, but you may,
Lordship-
I think, because where is the order,
The impugn order,
condonation order?
the order is lordship, I'll take section, it's in page 65, lordship. Before that, lordship, in a check bounce case, lordship, when a case is filed, if there is a delay, the trial court cannot condone it.
Yes, that is why, that order has to be challenged.
Yes, lordship, I have challenged that. Before that, lordship, I'll just take to
So that
case.
order, by way of this passing petition, can that be?
Yes, lordship, that can be. I have a judgment also in regard to that.
What the judgment says?
Lordship, it says that under 482 it can challenge, and the notice has to be issued to the accused person, that is to the one who has given the check, if there is a delay petition. And lordship, here also.
No, that is there. In a delay petition, notice has to be issued.
Yes.
Without issuing notice, of course, can't be.
Yes.
But then what I'm saying is what lies against that order? Is it 482?
482, lordship.
482?
Yes, lordship.
Where is it?
Lordship, I have here, like, there are several cases. This is a case of, lordship, I couldn't find.
What it says? No.
It says it's a case of Uttarakhand High Court, lordship.
Where is it? Relevant portion?
Lordship, the petition, may I read on the delay condonation, negotiable instrument. The court was the proceeding of criminal.
Para?
Lordship, the final decision on, I'll just be precise, in the first paragraph, sir. The petition under section 482 of CRP was summarily disposed of, passing the impugn order and directing the magistrate to give an opportunity to the accused person before passing an order of application move under section 142 subclause B of the negotiable instrument 1982. And lordship, here also.
Okay, will issue notice then?
Lordship, since I'm an interim prayer, lordship, because lordship, May I lodge, I'll take in the lordship,
So the
If-
proceeding, what is the last order? Have you annexed the last order passed by the trial court?
lordship. That lordship, I
Page
have
72?
fixed, page 74. After that lordship, I have not, page 37 of 2024, that is for SRN experience. I have appeared before the honorable court.
Is this an impugn order?
Yes, lordship, this is
Which
the
one, 72?
72 to 70, 72 and 73, lordship. I have challenged the board because since there is no any
It's
legal depth.
different order, okay. No, it can't be. Okay, anyhow, we can issue.
Lordship, I have an intimate prayer.
What is the last fix for what? Next date is fixed for?
Lordship, I had appeared before, I have appeared before the learned trial court and I filed my DS that my lordship, and since lordship, the notice has been direct and straight way in a mechanical way without even notice to me.
Okay.
Lordship, here is another judgment of
What is that?
Chhattisgarh.
What is that about?
This is also lordship says that the notice has to be issued to the accused person before condoning of delay.
Okay, Mr. V. Jamo. Non-counsel for the petitioner. Para. By filing this application, a petition under 482 CRPC stroke 528 BNS for crossing of, and then just a minute, this is an, leave that, this is an application under section 482 CRPC stroke 528 BNS for crossing of the complaint case number, your prayer, number 23 stroke 2024 under section 138 Negotiable Instrument Act pending before the Judicial Magistrate First Class Capital Complex UPR. Issue notice returnable by 3 weeks.
3 weeks, lordship.
3 weeks. Start. The petitioner shall take steps upon the respondent by a registered post with AD within 3 days from.
Yes, lordship.
Start. List this matter after 3 weeks. Till the returnable date, it is provided that, sorry, it is in the interim, it is provided that till the returnable date, the further proceeding of the complaint case CR number 23/2024 under section 138 NIA Act pending before the Judicial Magistrate First Class UPR shall remain state.
Deeply obliged, lord.
Yes.
I'm for the respondents, your lordship.
Yes. You for the petitioner, applicant, appellant,
Respondent.
respondent,
Yes.
yes.
Lordship, here, my client has informed me that, they have, amicably settled the matter in, Pasighat Court. And they have already paid, 30 lakhs amount and 15 lakhs is remain. So they need, some more time to deposit the 15 lakhs amount.
So settled,
Yes.
okay,
So the part payment has already been made by the appellant.
okay.
So upon the appellant that whether they withdraw the appeal or to pay the remaining balance amount. So a date may be fixed after 20. The date is 20 for further payment by the appellant.
Okay. Miss. Miss. Dirilo,
Yes, sir.
Land Council for the appellant. Also had Mr.
A.K. Misra.
A.K. Mr. Land Council appearing on behalf of the respondent. The Land Council for the party submits that the matter, the parties are on the process of settlement of the case and prays for some time to complete the settlement of the case between the parties out of court staff. The prayer is allowed, prayer is allowed. List this matter after the ensuing summer vacation.
Right, your lordship.
Okay.
May I please, my lord?
Yes.
My lord, this bail application is filed in connection with Itanagar PS case number 133/24 under section 21B/29 NDPS Act. My lord, before I made a brief act of the case, to read out the FIR, my lord.
Yes.
FIR is page number, my lord, 12.
Yes.
Annexure. With due respect, I would like to inform you that on 3/8/2024, around 19:15 hours, information received from reliable sources that three persons, namely Sri Taba Gatung, mobile number so and so, Beckham Tilly and Tok Alex are coming to Itanagar from Duimuk to sell heroin drugs in 6 kilo near Shiv Mandir. The above information was informed to SP Capital via telephone, and he directed to act on the information and apprehend the suspect and seize the drugs. Since the information was received in short notice and needed immediate action, written approval could not be taken from SP. Accordingly, Self Constable Navam Chakum, Constable Naik, Nick Kawak, and Constable Sandeep Yadav were directed to apprehend the above mentioned suspect and seize the drug. The team led by me left as PS for 6 kilo Itanagar. Takis Yakar so and so, Gute Gamlin, son of so and so, who were nearby there, apprised of the matter, and they volunteered to witness the search and seizure. The suspect were apprehended in 6 kilo near Shiv Mandir. Their personal search were conducted in the presence of Oli Koil, Special Magistrate, Judicial Magistrate First Class, and DPS. After duly serving notice under Section 50 of NDP Acts, during search, the following were seized from the suspect in presence of independent witness and after all the necessary legal formalities. One number Alex Camder, my lord. Alex Camder, so and so, one red colored soap case containing suspect heroin 9.68 gram and Marcus A. One
And
heroin.
the accused name is?
My lord, herein accused name is Lord Taba Gatung, my lord. Taba Gatung. So here alleged that accused Taba Gatung, they have seized 11.73 gram, my lord. 11.73 gram. So my lord, after this FIR was launched by Sub-Inspector Shamul Ngapak from Itanagar PS. The fact of the case is, my lord, that on 3/8/24, while this accused person and one Teli Beckham, who is a co-accused here in Malad, they both were in Duimuk, just TQ Sports Bar restaurant opposite of Power House Duimuk. So while they were at something inside the bar restaurant, so in the meantime, team of police came and arrested the Duimuk man. But here in the FIR, FIR is mentioned that they were arrested from 6 to Itanagar. In fact, this accused was arrested from Malad Duimuk. So it is admissible fact that Malad some small quantity was recovered from this accused person, Tabagatung Malad, hardly 3 to 4 gram, but they have shown that 11.72 gram Malad. So thereafter, Malad, this accused was arrested and they were sent to police custody, police remand for 5 days, and thereafter accused was sent to judicial custody, Malad. So now accused is in judicial custody, Malad. Since last
Intermediate.
yes, my lord, 59 days. Last 59 days. And my lord, the co-accused one Teli Beckham was already granted bail by the Honorable Session Court, UPR, on 23rd, 23/9/24.
How much was recovered from Teli Beckham?
Teli Beckham, my lord, they have not specifically mentioned that how much quantity was recovered from accused Teli Beckham. And my lord, this accused person has also filed bail application before Honorable Session Court, and it was rejected on 27/8/24, my lord, on the ground that the case was in initial stage, and I of the case has to arrest other co-accomplices. That bail was rejected on that grounds.
Now the case is still under investigation.
Yes, I have objection regarding this bill. Teli Beckham here co-accused who was released on bail. Here, principle of parity does not apply because only from his possession bike was seized while he was released. And from this accused, this instant applicant, 11.39 gram heroin was seized. And he was under from his possessions. And he obtained that, procured that substance from one Ramjan from Harmuti area. And this alleged convict Tok, who was released on the bail, was procured the same substance from Rahim Ali. It was revealed by themselves before the IO, and these 2 persons are still absconding, not apprehended. Here in this case, 3 persons were apprehended.
Alex Kamdev.
Alex Kamdev Tok. Here, three accused were arrested in this case, but these 2 main supplier, Ramjan from Harmuti and Rahim Ali, this actor Nijuli, is still absconding. So here mandatory period is 60 days, though date of arrest is on not mandatory is not yet
Lord,
over also.
58 days, my lord, is in judicial custody. And my lord, my fear is that the accused father, who is 85 years old, is suffering.
Mother is there. Mother is there.
Mother already died. Mother already died, and my lord, father is suffering since due to old age since last many months. And also, the concerned primary health and Sagali has referred to TRIMS for further treatment, my lord. So, my lord, there is no one to look after the old age father, my lord.
NDPS case.
I have also, my lord.
This is a very serious impact on society, societal issue involves here.
If, my lord, if accused is the bona fide, local bona fide within Papumpare district, if honorable court will consider bail also, there is no chance for evading of trial or abscondings. Is a permanent resident of Sagali, within Sagali circle. So my lord, here co-accused has already granted bail by the Honorable Session Court on 23 of this month. And given with strict term and condition, my lord.
Whether the IO has indicated that the investigation is at the verge of completion, etc., not indicated.
Not indicated. Because these two main suppliers were still to be yet to be arrested to this main supplier.
And there is also my lord, young boy of 20 years age and college going students.
The matter is still under investigation, I think on the same ground, learned, because there is a prima facie case against. him.
Yes, primary basis.
Yes, my lord.
And
that-
then the learned trial court has also rejected on the same ground, it appears.
My lord, here I made the ground, the medical ground. My father is sickness, ailment.
Have you
since-
annexed the medical document?
My lord, yes, I have enclosed the medical prescription of page number, my lord, page number 23 to 24.
Medical prescription of
My father, my lord. who is
Your
80
father?
Yes,
No.
my father,
Hmm.
who is 85 years old, my lord. So only I am the last son, I'm looking after my old age father, my lord.
First, second,
My-
third courts are there.
No, no, my lord, only my sister is there, who was already married, my lord.
Hmm.
And my lord, Sagali, the concern that community health center report him to TRIMS.
Unless.
So my lord, I may grant, consider is any strict term and condition.
How many days you said?
My lord,
58 days.
Today is 58 days. I mean,
So
I
you
mean,
are
within-
entitled for bail after 60 days.
Yes, my,
Wait for some more days. then.
my lord,
Some more days.
my lord, Puja vacation
That
also
will be better,
approaching.
otherwise I'm going to reject it.
Lordship, Puja vacation also approaching, so
Hmm.
my lord may consider any strict term and conditions.
No, it's a drug case, and then there is a prima facie case against him for his involvement and recovery made from him. It's
My lord,
difficult.
I am,
On
my
what
lord-
ground it will be released?
my lord, I am not going into the merit of the case, my lord.
Hmm.
I'm just submitting on my domestic grounds that my father is seriously ill. So my lord may consider any strict term and condition.
So 60 days, when it will expire?
Arrested on
Tomorrow, my
3rd August.
Get it listed on 4th. That will be better for you.
Yes.
Otherwise, I'll reject.
My lord, on third, my lord.
What will be the last working day
what is the
before
last working
before
day?
vacation?
Okay,
Before
okay.
vacation. Yes.
Third.
Fourth.
Third,
Fourth.
third will be the.
No, no, no.
fifth.
Third.
Fourth will be the last working day before vacation.
Yes.
From 5th, it will begins. Vacation will begin.
On third,
Third, how many days?
it will
They
be
will complete
above 60 days.
above 60 days.
Yes.
No, no, exactly it falls 60 days. August is 31. That will be 61 days.
Because my lord,
60,
the
60,
honorable,
third. So
61st
fix it
day.
on third.
Mm.
By third, if you can produce the updated CD, or if if the charge sheet can be filed today, tomorrow.
Yes, if your receipt is directing to produce updated CD, then it may be fixed on 4th. So I have to communicate also because we have to communicate through WT message and response and all.
Whether the charge, because otherwise it will be all the same.
It may be written till next hearing. It may be written,
Only the
updated
only the
status report.
only the information we have to obtain instruction is that whether the charge sheet has been filed or not.
Exactly. Obliged.
Mr. On the prayer of Mr. Ram, Thane Council for a petitioner, list this matter again on third. Third?
Yes.
Third, okay, stop. In the meantime, Mr. Tadao shall also produce the updated CD.
much obliged.
May it please your lordship. Lordship, this is a PRS bail application. On the earlier date, CD was called for.
Lordship, this perhaps this matter has become infructuous. Why? Because your Lordship, CD was called for, but now the investigation has been culminated into FR, your Lordship.
Okay.
Final report, which was filed on 1/8/2024.
Final report.
Yes, your Lordship. Final report number 134 of 2024, dated 1/8/24.
Okay. So then,
If it is closed, then as final report has already been filed with regard to the said PS. As final report has already been filed, I think,
you are protected by the interim also?
No interim, your
no
Lordship.
interim.
No interim.
Okay. Now then, he will not be arrested.
No, he will not be arrested, your Lordship. There is no any apprehension at all.
Okay.
this court will take into note that the said submission
yeah.
made by the PP. Court will take into note the said submission made by the PP that the FR has been filed.
You are Mr. K.M.
Mohanto.
Mohanto, counsel for the applicant. Mr. P. Okay. Then additional PP submits that after completion of the investigation, the IO of the case has submitted the case into final report
White ETA PS FR number.
by,
White ETA PS FR number.
Itanagar.
PS
PS
FR number 134 2024
2024.
dated 1/8/24.
Dated 1/8/2024. Start. In view of the above, in view of the above, this
Pre-arrest.
AB 20 has become infructuous. Accordingly, this case is disposed of on being infructuous.
Yes, sir.
Okay.
Deeply obliged.
Yes.
Your Lordship, may Your Lordship,
Yes.
Your Lordship, on last occasion, this honorable court has observed that this entire case is born out of civil in nature. So, considering that fact, Your Lordship, on last occasion, the interim was granted to the accused person. And
What
the
happened? He was directed to appear before the IO.
Yes, Your Lordship. So,
Whether he appeared before the IO?
yes,
What happened then? Was he arrested?
the execution part has been done, Your Lordship, before the IO of the investigation officer. Before the IO of the case, Your Lordship. Your Lordship, may I take you in page number
Just a minute,
70?
Just a minute. What is this?
CD receipt, CD.
Video also.
It's about money taking 8
Seems
lakhs.
like civil matter.
Yes, 8 lakhs investment and 4 lakhs already been paid.
Okay.
And she
Mr.
appeared before.
N. Kakum.
N.
Kakum.
Not counsel for the petition. I've also heard Mr. Gitaro, Daniel Edison PP. So he has appeared, already released.
Yes, on the strength of interim.
By an order dated 23/9/2024. the accused applicant was granted an interim anticipatory bail and directed interim anticipatory bail directing that in the event of his arrest in connection with the New Delhi PS case number 43, 2024 on a section 417, 420 of the Indian Penal Code. He shall be released on interim pre-arrest bail on furnishing bail bond of rupees 50,000 with one surety of like amount. So, it was the petitioner was further directed to appear before the eye of the case within 7 days. Within 7 days, before within 7 days, start. Bad. Accordingly, the accused appeared before the eye of the case on which date? 30.
Yes, Your Lordship, on 30.
2024. Start. On his appearance, the accused, her name is Srimati Gopi Prasad Sonam, was arrested. But however, she was released on interim anticipatory bail on execution of a bail bond of rupees 50,000 on the strength of the interim anticipatory bail granted by this court on 23/9/2024. Start. Since the accused is cooperating, I suppose.
As per
Mm,
IO,
okay, yes.
she is not receiving any response, not receiving in the court call or response after
But
that.
she appeared.
She appeared.
Mm.
It may be in condition, it may be also reflected that as and when required,
Okay.
she shall have to be appeared.
This accused has already been arrested and released on bail. This bail application has become infructuous. Stop. Accordingly, the interim anticipatory bail granted to the accused on 23/9/2024 is hereby made absolute, made regularized and made absolute. Stop with the same terms and conditions, with the further condition that the accused applicant shall appear before, shall cooperate and appear before the eye of the case as and when called for. This bail application shall be read along with the, this bail order dated, the bail order shall be read along with the order dated 23/9/2024. With the above, this bail application stands disposed of.
Obliged, Your Lordship. Deeply obliged, Your Lordship.
An FIR was lodged against one Mustaq Ali. And pursuant to that FIR, my lord, we have been my lord, directed to appear before the investigating agency by issuing, my lord, notice under section 41A. Therefore, we are the bona fide purchaser. We purchased two dumper from the, my lord, accused person who was implicated in the said criminal case. And we have produced, my lord, in support of our contention, all relevant documents, including, my lord, bank statement, including no objection certificate, my lord, registration certificate issued by the government of Arunachal Pradesh, then registration certificate issued by the state of Assam, DTO, my lord, Chief Shagar. Therefore, my lord, since we are the bona fide purchaser, we have our reason to apprehend that possibly, my lord, we may be implicated. So some protection be given. We are ready to extend our cooperation. We are ready to appear before the, you know, investigating agency.
Oh, what is the allegation?
Pardon, my lord?
What is the allegation? Let us see the FIR.
Yes. Lordship may kindly come at page 26.
26.
26. May I read, madam?
Yes, please.
I availed the vehicle loan of 2 truck dumpers from Tata Motor Finance Limited, Lakhimpur in the year 2019, and 2 more dumpers in 2021, funded by same finance company under the firm of name Sri Darko Infratech Chimpu, Itanagar, Arunachal Pradesh. In the year 2021, one Mustaq Rahman from North Lakhimpur, Assam, approached and proposed to buy two of my dumpers. After threadbare and persistent approach, I agreed to sell 2 dumpers by a registration number so with the following conditions: that he will pay some amount as part of purchase proceeds of the dumper, that he will pay all dues payable to finance company, Tata Motors Private Limited, Lakhimpur, as soon as I hand over the said 2 dumpers, that he will also pay all taxes, revenues chargeable by the administration and revenue officer on the above 2 dumpers, that he will change the registration in his name as I hand over the registration document to him after paying the dues owed to finance company with my sign and signature in Form 35, which is meant for transferring the ownership. But sir, to my surprise, I lately came to know the following illegalities: that he has still not paid the loan dues or installment amounts even after 2.5 years of the agreement, as was payable to the finance company, Tata Motors, etc. That he has sold and transferred the dumpers to one Nivas Thakur, without the present petitioner, without taking my signature in Form 35, mean for transferring the ownership, that all papers like so-and-so have expired, that insurance of the vehicle have not been renewed for a long time, that he might have issued fake and false documents while transferring or selling the dumpers, that the several occasion he has issued inadequate balance and bond check leads to the Tata Motors. This is the allegation basically against the Mustaq Rahman. Now, Lordship, kindly see, have a look at page number 31, annexure 4. This is the notice issued under section 41A, whereby the petitioners were directed to appear for interrogation. And Lordship may
You did not appear.
No, my lord, date is not yet come, 5th of October. And my lord, clause K.
5th October.
Yes, clause K. You are directed to produce the dumper, track, etc., etc. We are ready to do everything, my lord. I can give an undertaking that, my lord, we will, my lord, extend our cooperation assistance to fullest, as possible, my lord, on our part. The only anxiety is that, my lord, we may not be, my lord, implicated or may not be apprehended. Some protection will be given. Because my lord, from record it appears, various records I have annexed,
How many applicants?
2 applicants, my lord. It's a common affair, same allegation.
The dumper was taken by whom?
Pardon, my lord? Dumper was, we purchased the dumper from that particular
Purchased
person.
by whom?
By Mustaq Rahman. Mustaq Rahman is implicated as accused in the affair.
Hmm?
Mustaq
Implicated
Rahman
as?
is the accused. He is the accused, my lord, in the affair, which was lost by informant.
Just a minute. Informant is?
Informant is one Tadat.
Okay. Who is this Mustaq?
Mustaq is the, my lord, who purchased the dumper in
And
terms
who
of
is this-
agreement from
And
informant.
the applicant is, how he is connected with?
We are, my lord, bona fide purchase, we purchased the dumper from Mustaq.
Mustaq.
Mustaq is the accused. And
Okay,
entire
the FIR
allegation
is basically against Mustaq.
Exactly, my lord. But our apprehension, my lord, to some extent may be reasonable. Because, my lord, direction
So
was given
this
to
petitioner number 1 purchase one dumper from
one
Mustaq.
dumper and we have to purchase the other dumper. There are 2 dumpers.
Okay, where have you stated that you have purchased?
We purchased, my lord,
So after purchase, you have re-registered also.
the government of Arunachal Pradesh, they have issued no registration certificate, saying that registration may be, my lord, done by the purchaser in Assam. I'm showing you all my documents one by one. Okay, kindly, annexure 1, have a look, my lord. Page 17.
Just a minute. 221. Mustaq Rahman. So Mustaq Rahman is not with us.
Mustaq Rahman is the accused person.
Accused.
Yes.
Anywhere your name also mentioned?
No.
But
Our
then you
name-
have been called by this, you have been summoned to appear.
He was summoned by the police my lord, investigating officer under section 41A. At, my lord, page 20.
Page?
Page, just a minute, madam. At page 32.
The allegation against Mustaq is that he did not pay.
He didn't pay installment and accordingly, and that, beside that, he sold the dumpers to us.
So,
He doesn't even name, madam,
Okay.
to whom it was sold.
Okay, yes.
With the lawsuit, in the FI lawsuit, appears to that this is not a simple lawsuit, it's a serious lawsuit, because lawsuit, they have re-registration also lawsuit.
Non-payment only.
More about the re-registration
Payment,
also
but he
lawsuit.
subsequently has sold. I think is there any separate agreement between this Mustaq and the informant?
Madam, can we have it? Yes, madam. There was an agreement.
Not to sell.
No. They said, he said that moment he will pay the entire amount to Tata, he will be, madam, absolutely free to sell the dumper and get his name registered. And, madam, all document shows, my lord, Tata also issued, madam, no objection certificate. Bank also issued no objection certificate.
No objection certificate in favor of Mustaq.
Yes, madam, in favor of the original loanee, Tata.
Original
loanee who took loan from Tata company.
No, sir, it's a
Who
460.
issued no objection certificate against, in favor of, in whose favor?
Madam, Roshi, can you see at page 58?
58. Yes.
My lord, this is the certificate issued by Tata Motors, that is financer, in favor of, my lord, RTO, informing that vehicle is not
In favor of RTO.
RTO. In favor of, my lord, to RTO saying that vehicle is free from all encumbrances. we have to inform you that the said vehicle is no longer under our hire purchase or hypothecation agreement, Tata Motors. Therefore, it is absolutely free, and we believe.
Okay, this was, originally this Tata Motors was
Yes.
purchased by the informant.
Yes.
Okay.
Lordship, later lordship, case diary may be called for lordship because they had their, as per the lordship, page 31 lordship, the notice issued lordship and they have to appear on 5th October lordship. So case may diary may be called on 4th lordship.
Not Mr. I.S. Sharma.
Yes.
I.S.
Hmm?
Okay.
My name is not shown in the
Okay. Thank you for this. Planet, senior counsel. Senior counsel.
My lord, basically, I have not been designated.
Okay.
To be frank.
Planet
enough.
counsel for the petitioner. This is an application filed by. Mohammed.
May I just point out one thing, my lord? So far as, my lord, our part is concerned, moment you will appear before the IO, I will be in a position now to examine everything. And if bail is not given, granted, my lord, then there will be
Okay,
difficult on our part to.
Bablu Ali.
Intention will be-
Lordship, this affidavit lordship on the behalf of the Bablu lordship and the petitioner one only lordship. This two lordship, the affidavit is not lordship. This petition lordship.
Affidavit?
Affidavit on the respect of petition number 2 lordship is not the dear lordship. But lordship, they are undertaking or whatever lordship should be there lordship, authorized lordship. This is not there. Only one affidavit.
Only one affidavit.
Lordship. No, this not maintainable lordship. This
Authorized, my lord, there is no authorization, no, you just go, para 1 of the affidavit, duly authorized.
Where is the authorization?
Authorization is not.
Authorization letter is not with us. But he has made a statement on oath that authorized.
No. Where is the authorization?
Authorization, my lord, at page, my lord, affidavit page. At
My signature duly authorized lordship. should
At
be
page
there,
15.
This is affidavit by Bablu.
Bablu. And
Bablu
he
is
said
petitioner-
that.
Bablu is petitioner number 1.
Yes, and he said that I have been authorized to.
No, where is the authorization?
That letter is not with me. my lord.
Then.
My lord, I don't think, my lord, any authorization letter is necessary because we used to move the petition by making a
unless-
statement on oath.
Because he is filing bail application,
My lord.
not even authorized.
No, whether this statement is not enough, my lord. Statement what he has made on oath.
No. Statement is by the Bablu Ali only.
No,
Because
no,
he signed his affidavit,
that's right.
not the Nivas Thakur.
I am the petitioner. My lord, in our understanding, my lord, so what surprise me is
No,
concerned, my lord.
No.
An affidavit,
No,
one
no,
affidavit is
affidavit
filed.
has to be filed.
Each and every petitioner need not sign the affidavit, my lord.
No.
Only
Yes.
one person will sign the affidavit
No,
on behalf of all.
not even authorized.
It is a practice, my lord.
Authorization letter should be there.
No, because
Okay,
he is a
that is
petitioner,
the
he is a
basis.
petitioner. Even in the, you see, multiple applicant also.
My lord.
The person has to authorize,
My
the
lord.
person who is going to sign affidavit. Unless it is authorized, he himself declaring that I
Then, my
have
lord, if you want
authorized.
to do one thing, my lord, since the question is raised by my lord, my lord, rightly.
You file another application, bail application for Nibar Thakur.
My lord.
We'll pass order for Bablu Ali.
My lord.
This is an application under section 438. Of the Code of Criminal Procedure 1973, filed by the petitioner Bablu Ali, apprehending his arrest in connection with Jimpu PS case number 34/2024, registered on 35/2024 under section 406, 468, 471, 420 of Indian Penal Code. Within bracket GR number 593 stroke 2024. Start. The case of the petitioner is that one, sorry, written FIR was lodged by one Taher Nigla against one Mustaq Rahman for non-payment of the installment for being the cost of dumper. Two dumper.
Yes, two dumper.
Two dumper sold to him with further allegation that the Said Mustaq might have, just a minute. Whether the allegation is that Mustaq has sold or is might have sold.
Yes, pardon my lord?
Whether the allegation against the Mustaq by
Yes.
the informant is that he sold or he is going to sold.
Yes.
Sell.
Yes.
Yes, yes. And with the further allegation that the said Mustaq has sold and transferred the said dumper to so the Nivas Thakur's name is there.
Nivas Thakur is petition number 2.
The petition number 2's name is there, and Bablu Ali's name, has he mentioned?
Yes, yes.
No, Bablu Ali's name also here.
Bablu Ali's name is, my lord, affair, his name is not named.
Okay, so sold to
Not
one Nivas Thakur without taking any. Then illegal sold to Nivas Thakur. Stop. Basing on the above FIR, a case was registered, and the above PS case was registered against registered and registered stuff. The other case of the petitioner is that he has purchased one dumper from Mustaq Ali. So your contention is that you did not know that this.
I didn't know, we didn't know, bona fide procedure.
Okay. Without knowing that. With the belief that accused Mustaq Ali was bona fide with the true owner of the said dumper. However, the police, where is the summons by the police?
My lord, at page, my lord, 31.
51.
31.
31.
Annex 4.
However, The IO of the case has issued the IO of the, has summoned him under section 41A. To appear in connection with the above PS case. IO by letter dated, letter dated. With the 16/9/2024.
16/9.
16/9/2024 has issued summon to him under section 41A A for his appearance on in connection with the above PS case on 5/10/2024 at police station Chilpu staff. Hence, he has a reasonable apprehension that the police might arrest him in connection with the above PS case and cause unnecessary harassment. Hence, this application, pre-arrest, hence this application for granting pre-arrest bail. Staff and para. Issue notice, call for the case diary. Then the scanned copy of the case diary, staff. Miss Hage, Lanet additional PP has accepted notice on behalf of the state. Staff. Para. In the meantime, till the returnable date.
Lordship,
In the
case
meantime,
diary may be called for on the 4th or Lordship, 4th of October. Because from 5th Lordship, this court vacation will be started Lordship. Then 4th of October, the case
No,
diary
on
may
the
be.
fifth, he will appear before the police.
Lordship, that's why Lordship, on the 4th case diary may be called for. After go to the case diary, the bail may be, entry may be granted Lordship.
I may not be in a position to come on 5th.
Because Lordship, on the 5th, if he is appearing on the 5th, then this bail application is
No,
not.
let me appear
not
before
needed,
the,
Lordship.
let me appear before the police officer, my lord, to produce all relevant documents.
Because we have to see the gravity of the offense, Lordship, whether.
Returnable date, in the event of, he might not be arrested also because he is only the bona fide
Yes.
purchaser from Mustaq.
That's why
And
Lordship.
Mustaq is the main accused. He
This
is
wa-
not agreed by this person, but the Mustaq.
This way, Lordship, may not be arrested, Lordship. It may not be
No,
that's
that-
why, Lordship.
In the meantime, in the event of the accused applicant Bablu Ali is being arrested in connection with the above Thimphu PS case number 34, 2024 under section 406, 468, 471, 420 of IPC. He shall be released on interim anticipatory bail on execution of a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority. With the further, with the arresting authority, with the further condition that he shall appear, he shall cooperate and appear before the eye of the case again when called for. Para, list this matter.
On 28th, my lord.
23rd, Lordship.
On
No,
20
23rd, I will be out.
28,
28.
28.
28.
29, Lordship.
Huh?
29.
No, no, 28. Baki matter, 28.
No, 28 can.
Yes. And may I please, madam, pray one more thing, madam. Item number 21, this matter may come after vacation. Because I've checked up the record, they didn't appear. Notice was issued.
21.
21, madam.
Okay,
on
As
20.
prayed for by Mr.
The service is not completed.
Yes, yes.
Okay. Service not completed. Okay, third, Mr.
Take a protest.
Then, AK forecast, then counsel for the petitioner. 21.
28.
No,
Item 21.
petitioner. The service report upon
That's one number 2.
the respondent number 2 is still awaited. Stop. In view of the above, and as prayed for by the Lana Council for the petitioner, leaves this matter on 28.
But so far as the earlier case is concerned, our name may be reflected in the call list.
Yes. Okay.
We may miss the item.
Leaves this matter after 4 weeks by reflecting the name of the name of Mr. Purkastia and S. of
His name is there.
Sharma in the cause list.
Madam, both the
As
matter,
counsel for the petitioner.
both the matter will be listed matter on 28th.
Yes, yes.
My lord. God bless. I'll get through.
So this is in respect of one petitioner number 1.
I will file, madam.
Okay.
My lord, although my name is reflected here, my lord, I am not in the case, so my name maybe can be struck off from the Wakalatnama.
Item 13.
Yes.
You are no longer appearing in this case.
No,
Okay, who appeared then?
the petitioner by himself, who he is an advocate by himself.
Okay. No one appears on behalf of the petitioner. How Mr. Nalopada, who earlier appeared as counsel for the petitioner, submits that since the petitioner is appearing in the case, petitioner is appearing in person, no? In the case, his name may be withdrawn and struck, withdrawn and deleted from the course of, course list. Stop. The prayer is allowed. The name of Mr. Nalopada as advocate for the or as land counsel for the petitioner may be deleted. Stop. List this in absence of the land counsel for the petitioner. The case stands adjourned. List this matter after 4 weeks. Okay. Yes.
May I, Your Lordship? Your Lordship, I am on behalf of S. Koyang for the petitioners. Your Lordship, the conducting counsel is at Delhi. He has a matter, has a matter over there, and he has asked for prayer to list this matter after.
Yeah, you are Mr. You are Mr.
E. Payeng. E. Payeng.
E. Payeng.
Yes, Your Lordship.
Submit says the conducting counsel, Mr. Subukoyan, is out of station. And is on his behalf for adjournment of the case, to which Mr.
L. Teni for respondent.
L.
Teni. T-E-N-I.
Planning counsel for the apparent
Respondent.
respondent has no objection. So accordingly, the prayer is allowed. List this matter after 4 weeks. 4 weeks.
Affidavit, my lord, affidavit on behalf of respondent has been filed. Affidavit on behalf of respondent.
Filed?
Yes, it was filed on,
It is on record.
yes.
Okay, it's fine. Yes.
Deeply applied.
Next. Yes.
Service lawsuit not completed.
Still await. No one appears on behalf of the petitioner while Ms. L. Hadi, Learned, additional PP is present. the office note dated 30/9/2024 to reflect that the service upon the respondent number 2 is still awaited. In view of the above, comma, least this matter after 4 weeks.
Right.
My lordship.
Yeah.
Lordship, as per office note, lordship, the respondent number 1, 2, 3, 4, 6, 7, 8, and 9 are still awaited.
Mr.
K. Lauren, lordship. On
K.
behalf of
Lauren,
four
I'm
more.
counsel for the petitioner. You are no one, okay. Petitioner, huh? The office note dated 31/7/2024. So, four, okay, reflect. It's earlier. So you see there is, are you going to take fresh steps upon the respondent?
Lordship, some more time available, lordship. Some more time available.
Some more time.
Lordship.
Okay. Yes, the service, the reflect that the service report upon the respondent number 1, 2, 3, 4, 5, 1, 2, 3,
5
4,
is complete.
6, 7, 8, 9, and 10 are still awaited. In view of the above, the case. In view of the above, comma, least is matter after
4 weeks.
4 weeks.
And lordship, there is an interim order.
There is interim also.
Lordship.
The interim order was earlier. Interim order was earlier shall continue to the next stage. Okay.
All right.
Yes.
Perhaps your lordship, service is completed in respect of all the private respondent, your lordship, and they have entered appearance.
Lord, this is our first appearance.
So now,
Since service is completed, Your Lordship, this matter may be fixed for admission hearing, Your Lordship.
okay.
J.
Mr.
J. Sring.
J.
Sring.
Sitting, Lara counsel for the petitioner. I've also heard Mr.
M. Combo on behalf of Mr. Arsoner.
Okay, then first Mr. Criminal petition, Mr. Okay, here for the additional PP for the state, and Mr. L. Combo for state respondent now, L. Combo for respondent number
2 to 26.
2 to 26. Stop service. The Lana counsel for the petition submitted that the service is completed. In view of the above, list is matter after
Puja vacation.
after puja vacation.
For admission hearing.
Admission call.
Yes, sir.
For admission hearing.
Yes, sir.
Obliged.
Deeply obliged.
My lord, service report in respect of sole respondent, my lord, is still awaited, my lord.
Mr.
The other one.
Planning counsel for the petitioner. Okay, this. The office note dated 30/9/2024 reflect that the service upon the respondent number, the sole respondent is still awaited. In view of the above, comma, list is matter after
My lord, there is an interim order.
after 3 weeks. Stop, para. The interim order was earlier shall continue to the next stage. Okay.
Yes, may I please, Manoj? Manoj, this joint application petition filed by the accused victim and informant for quashing of FIR. And LCR was called for last occasion, Manoj.
Trial court record received or not? Not yet. Record has come. Okay, it's fine, fine. Whether for the respondent appear?
My lord,
Quashing.
status, yes, quashing of FIR, my lord. Section,
Oh,
at around 11 a.m. dated 1 April 2019. On the other hand, I entertained a matter for compromise but refused. Rather, he brought a letter Luifon Dao in addition of beating with bamboo stick, kicking, and compel of boxing and slapping him. This is the allegation, my lord. So on 1 April 2019, this accused person and accused the petition number 1, my lord. And then informant is petition number 2 herein, and victim is petition number 3. Accused and the informant, they are neighbors, my lord. They are residing in same compound, same place at UPR 2 village. So on particular day of incident, that is 1 April 2019, while accused was coming back from his office, and on the way, we are seeing that the shuttering of that construction building of the petition number 2 was fell on the roadside, and he was just arguing with the labor.
What are these page number 37, 38, and 36, etc.? This is illegible, totally illegible.
My lord, I have made typo is there.
These are it, huh?
My lord, this photograph is, I have obtained case, chart sheet, which is similar, my lord, which is photograph, my lord.
Okay.
Photograph, my lord.
Okay, then thereafter what happened?
My lord, shuttering was fell on the road was blockage. So accordingly, he was argued that lever, that blockage metal should be, that should be cleaner. So in the argument, there was some pushing and pulling.
Okay, then thereafter what happened? So leave the incident.
And the case was registered, and thereafter, my lord, case was registered and trial was begun before the learned court.
Okay, case charge sheeted.
Charge sheeted.
Under section.
Initially, my lord, case was registered under section 447, 323 IPC. But in charge sheet, section altered. 323 was altered under section 324 IPC was altered.
Okay.
And trial was
non-compatible.
Non-compatible.
What happened in the trial court? Did you pray?
Trial court,
prayer?
yes,
Charge
we have prayed, man.
With a charge framed against accused?
Yes, man.
Okay,
Section
you have
320.
you have made a prayer before the.
Yes,
before
my
the
lord, we
trial
have
court.
made prayer before the since matter has already compromised between the victim and the complainant. So
the
trial court
says?
has said that since section 324 is non-compatible nature.
By which order it is referred?
My lord, that order sheet may be there, so I have not enclosed.
Not annexed.
I have not annexed that order sheet, my lord.
Okay. So how do they?
And-
how do we
and
know
thereafter,
that
my
you
lord,
have made a
parties
prayer
has-
for the trial court?
Parties mutually settled the matter
The settlement was before the filing of charge sheet or after filing charge sheet?
after filing of charge sheet.
Or before the framing of charge or after?
After framing of charge.
After framing of
Yes,
charge only?
Yes, yes.
Then,
The party has settled.
since you are not discharged, then you came into compromise, sir.
My lord, in fact, section was altered in the charge sheet under section 324.
No, that is why, because after there only, after hearing,
Yes.
then a charge framed against you on being found prima facie case against you.
Yes, my lord, that is there, but since they are relatives also. this
Now
is-
the trial began, and during the trial only, when you apprehend that there is a likelihood of conviction, then only you came to compromise. It will
My
be
lord,
difficult.
My lord, that is there, but in fact, this
How many evidence has been recorded till now?
Only one, my lord. Informant evidence are only recorded.
Informant.
Yes, only.
So the
Yeah, my-
material, there is a material.
My lord, he
Yes,
has
thank you.
whatsoever is FR he has narrated, the similar he has narrated before the trial court. Based on the
Now,
FR.
if he has already recorded,
Yes.
so wait, let us see the evidence of that.
Only FR, based on the FR he has narrated before the trial court.
That is why.
Yes.
But then what he has stated before, the trial court would remain as the evidence. If there is a material, it will be difficult.
Since, my lord,
After recording of the evidence, if there is nothing, or before recording of evidence, if there is nothing,
in fact, my lord, this accused has compensated the victim also.
maybe,
After
but,
settlement.
maybe, but then it seems. This is, okay, trial.
The section is.
What is the name of the informant?
Gyamar
Gyamar Thakkar.
Gyamar Thakkar, alias Bharat. Yes, ma'am. Cross-examination was not done, madam, because on that day.
Cross also not done.
Cross not done. Only he has given examination in chief. And thereafter, he was frequently called by the learned trial court, but he was not turned up. So cross could not done.
See, he came with the thou, with thou. So the labor, he came with thou. Oh, such a small dispute. And then see, the informant has stated, this is his deposition. Thou, Lati came and then he also threatened. This is clearly in the evidence. So this is exactly in the line of the FIR. He has been consistent in his evidence. Now in the evidence, there is a prima facie case against you. Now when knowing there is already there is an evidence, how do we compromise?
Madam, since they are relatives accused and then the
No,
informant.
the relative has implicated you.
Yes.
The
yes.
relative.
They are in same.
If relative, he should not have implicated you.
Same
With this.
is sure.
You came with thou and stick. Then again, when it was snatched away, you still threatened to come again with the stick and to assault the labor, as if the labor is not a human being. Started using boxing kick, using those stick. Proper. Yes. So under the circumstances, what is to be done?
Lordship, as per the Lordship, this petition, they have jointly Lordship compromise Lordship. And Lordship, as per the Lordship, there is no Lordship. I'm just assisting the court Lordship. Here this Lordship, this injury Lordship report is not there, and maybe it's not grievous Lordship. And Lordship, as per the record, I have gone through Lordship. They have applied before the Lordship MFC court that they will make compromise and they will come before the court for the quashing Lordship. It is their Lordship. Here in the record Lordship. So they have given the opportunity to come before the High Court for the quashing. It is, I have just seen Lordship.
When they pray, make a prayer.
Lordship. And Lordship, moreover, if the Lordship
Automatically the court
chances of conviction is linked, then it can be quashed Lordship. Because Lordship, here Lordship, only 443, 447 and 3 Lordship 24 Lordship.
447. See
Lordship.
the evidence clearly reveals the 506 is also there.
Lordship, as per the Lordship, this victim statement Lordship, they have Lordship, he only stated that he assaulted me with a bamboo stick. There is no way he is Lordship stating about the Lordship, the lethal weapon Lordship.
Yeah, he has given in evidence.
Lordship, that's why Lordship have the inherent power to quash the any state Lordship. This is just assisting the court Lordship. As per the Lordship, this under 482 Lordship. Before Lordship pronouncing judgment Lordship 313 Lordship, the court has the inherent power to quash Lordship. It's up to the court Lordship.
That is when there is no prima facie case.
Yes, Lordship.
So for ends of justice.
Lordship.
When there is a prima facie case in the evidence,
Lordship. Lordship, that's why Lordship,
Distraction.
injury report should be there, Lordship, because if no injury report, Lordship, if the injury is not vital,
Now, you see the
Lordship.
threaten, he threatened,
That's why, Lordship, only that's much, Lordship.
he kicked,
My lord,
boxed.
my lord, since party has arrived mutual settlement and whatsoever victim has suffered and accused has already compensated my lord. So based on that, they have also executed a deed of agreement, which is enclosed in page number 65, my lord.
Now, whether this victim has been made as a party
Yes,
or they are joint petition
yes,
by, how many victims are there?
only one, my lord.
Only one labor.
Yes, one level. So my lord, in such circumstances, if parties mutually settle and then if trial may be continuous, so there will be no chance for conviction of the accused. So it will be just futile exercise, my lord. And victim is yet to be examined, my lord. So definitely victim will not adduce any evidence against the accused person once they have arrived settlement.
You have an authority where there is evidence that there is a prima facie case against the accused can be compromised and by this court.
Yes,
You
my
have
lord.
an authority to solve.
My lord, because since section 323, 324 IPC is a punishment is very less, my lord, only 3 years imprisonment. And then there are so many citations given by the honorable.
Show me one connected with.
So lordship, if that so I'll allow to next that may be given, I'll bring citations, my lord. Today I have not bring citations.
Heard Mr. Angama, Direct Counsel for the petitioner. I have also heard Ms. Elage, Direct Assistant PP for the state staff. Okay, so I'll pass order. In the meantime, you give. Okay, my lord. It will be disposed of today only, but then in the meantime, by tomorrow, you give.
Tomorrow is holiday.
Day after tomorrow.
Yes.
Will not keep it for day after tomorrow. I'll keeping it, I'll dictate the this one, the fact. Okay, in the meantime, you give authority if there is, you said there is.
My lord, exact authority
Then
is not there. my lord.
otherwise it will be rejected.
But my lord, so in that case, my lord.
So the option, it will be, it is disposed of only. The last line is remain, if there is authority, it will go in your favor. If there is nothing, it will go against. Okay.
My lord, this honorable court has ample power for passing of affairs.
There is power. That is why I am saying you empower.
Yes.
You support the power of the High Court.
No, my lord.
So that the High Court based on it.
Will submit citation.
Because there is evidence.
Will cite.
That is why I am saying. Otherwise, you see, if there be no evidence, then saying that it will be a futile effort on the part of the court, and then it can be.
My prayer is that, my lord, since victim can have already settled, if suppose tomorrow
Settlement can be done. Anytime settlement can be done. We know, everybody knows. If the person is owner and he is a laborer, why the settlement can't? Settlement will be done only. But then at what cost? Then the person who has the money, they'll do whatever, anytime. And again, it will be settled. Or then who will be fear about the law and code?
That is there.
Something has to be there. Something has to be there. Even if he's how so high he may be, at least he should appreciate. He should respect the human being.
That is there.
So then, and then a person who doesn't have any resources, he doesn't have anything, no right to survive also, because he can't settle. We have to protect that also. We have to
Yes,
see
yes.
that also. So that is why you show us the authority, show me the authority, I'll pass order.
My lord, will furnish citations. Honorable Apex Court has
Then
given.
we'll take up on third. You bring,
Yes.
okay. Then hard, after that, is prayed for by the Land and Council for the petitioner. List this matter again on third. Of
Much.
Yes.
Your Lordship, I'm on behalf of the conducting council, U Bori.
Yes.
Your Lordship, he is currently out of station.
This is also quashing petition.
No, Your Lordship, here, interestingly, they have challenged on the legal aspect that for computation of limitation, 468. He is aware of
Yes,
this
yes.
468, that when it has to be computed from the day of the commission, till when, till taking of cognizance or filing of the FIR or filing of the charge sheet. This was the issue. According to them, it should be computed from the day of the commission till the filing of the charge sheet, according to them. But according to us, and so far as the settled law is concerned, as on that, Your Lordship, it will be from the date of commission of the offense and filing of the FIR. Interestingly, in GR case, and in CR case, it will be from the date of commission and filing of the complaint before the concerned court.
Okay, so who is the council?
You Bori, Your Lordship.
U Bori,
Yes.
Your Lordship.
You Bori. Okay. Mr.
E Payeng.
Land Council submitted the conducting council, Mr. U Bori, is out of station. And on his behalf, prays for adjournment of the case. For
4 weeks.
4 weeks. Okay. Mr. The Land Council for. So the Land, additional PP is present, staff. Is prayed for by the Land Council for the petitioner. List the matter stand adjourned. List is prayed for by the Land Council for the petitioner. Staff, comma. List this matter after 4 weeks.
Yes,
Okay.
sir. Deeply obliged, sir.
Deeply obliged.
May I please, Your Lordship?
Yes.
My Lord, today I'm confined only on 12 of Criminal Appeal 09 of 2023.
IA.
Yes, my Lord.
What is this IA about?
IA, my Lord, is for release of the convict on bail, my Lord.
Convict?
Yes.
Conviction for what offense?
For under 354A of IPC and Section 8 of POCSO Act, my Lord.
Okay.
Attempted rape, my Lord.
The paper book, you get it? Okay, Mr. and Father, Nalapada Land petitioner. I've also had Miss Hage.
Maybe Lordship, on the fourth Lordship, because paper book we have not received it today, Lordship. Tomorrow is holiday, Lordship.
Okay, on fourth.
Lordship.
Fourth is the last date. Okay. Nalhage, Land additional PP. And Mr.
Yes, yeah.
S. Iran. Land Council appearing on behalf of the victim. Is prayed for by the Land Council for the parties. List this matter again on 4th. This is item 30. Okay, come on, again, vote. For hearing.